We're going to move on to the next item of business, which is consideration of Business Motion 19379 in the name of Graham Day on behalf of the Bureau, setting out a timetable for the Stage 3 consideration of the Transport Scotland Bill. I would ask if any member wishes to speak against the motion. Press the request to speak button. And could I call on Maurice Golden to move this motion? Thank you very much, Mr Golden. No member has indicated they wish to speak. The question is that motion 19379 be agreed. Are we all agreed? We are agreed. Thank you. So the next item is continuation of Stage 3 proceedings on the Transport Scotland Bill. I won't repeat the procedural advice. I think members will be familiar. However, I will indicate that the division bell will sound before we have the first division of the afternoon. And Parliament will be suspended for 5 minutes to allow members to come to the chamber. So we're going to resume consideration of the bill at Group 23 on the workplace parking levy, and this is on the application of net proceeds. Can I call Amendment 171 in the name of Dean Lockhart in a group on its own? Dean Lockhart to move and speak to Amendment 171.
Thank you very much, Presiding Officer. I will try to be brief and use the notes that I abbreviated at 9 o'clock last night. Section 58, as currently drafted, requires local authorities to apply proceeds from the workplace levy only for the purpose of facilitating local transport policy. The purpose of Amendment 171 is to require that proceeds raised under the levy will also be used for supporting local business improvement districts, including town centre and high street regeneration projects in the local authority area. While the Scottish Conservatives fundamentally disagree with the workplace parking levy, if it is to be introduced, the proceeds should be used in a way that also directly benefits our high streets and town centres. High streets across Scotland are facing unprecedented pressure, with an average of 5 shops closing each week, according to a recent survey. This Parliament, therefore, needs to take action to revive our high streets. Ring-fencing proceeds from the levy for investment into high streets would be a positive first step. I would therefore encourage members to support their local high streets and support this amendment.
Thank you, and I call on the Cabinet Secretary.
Presiding Officer, Amendment 171 concerns the application of net proceeds from the workplace parking licensing scheme. The bill, as drafted, requires funds raised to be used for activities to achieve policies in their local transport strategy or the strategy of local authorities they are working jointly with for transport purposes. The local transport strategy will be developed to address local circumstances and may, at the local authority's discretion, include in it transport-related policies to strengthen business improvement districts or any other locally significant initiatives. Rather than seeking to determine initiatives to be supported at a national level, I believe it's appropriate to allow local authorities to determine how the funds are allocated through their transport strategies. And as a result, I do not support the amendment, and I would ask members to reject it.
Thank you, and I call on Dean Lockhart to wind up, to press or withdraw the amendment in his name.
Thank you very much, Presiding Officer. I appreciate the Cabinet Secretary is keen to increase funding for transport, especially given the dismal performance of ScotRail. But Scotland's high streets are facing unprecedented pressure from increasing business rates and a stagnant economy under the SNP. This amendment would give a much-needed boost to the high streets, and it would give local authorities full discretion on how to use this money for the benefit of town centres. I therefore encourage members to support their local high streets, support this amendment, and I move this amendment.
Thank you very much. So the question is that Amendment 171 be agreed to. Are we all agreed? Yes. We're not agreed. Now, this is the first division of the day, so I'm going to suspend Parliament for 5 minutes while we summon members to the chamber. Parliament is suspended for 5 minutes. Thank you, colleagues. So we're going to resume, and the question is that Amendment 171 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a vote. Members may cast their votes now. This is a 30-second division. The result of the vote on amendment number 171 in the name of Dean Lockhart is yes 44, no 59. There were no abstentions. The amendment is not agreed. Can I call amendment 12 in the name of Neil Bibby, debated in Group 21 yesterday? Neil Bibby to move.
Move.
That is moved. The question is that amendment 12 be agreed to. Are we agreed? Yes. Or not agreed? Move to a vote on amendment 12. The result of the vote on amendment number 12 in the name of Neil Bibby is yes 47, no 55. There were no abstentions. The amendment is not agreed. Call amendment 110 in the name of the Cabinet Secretary, debated yesterday in Group 20. Cabinet Secretary to move.
Moved.
Thank you. The question is that amendment 110 be agreed to. Are we agreed? Yes. We're not agreed. We'll move to a division on amendment 110. The result of the vote on amendment number 110 in the name of the Cabinet Secretary is yes 76, no 26. There were no abstentions. The amendment is therefore agreed. Can I call amendment 13, Neil Bibby, to move? That is moved. The question is that amendment 13 be agreed to. Are we agreed? Yes. We're not agreed. We'll move to a vote on amendment 13. The result of the vote on amendment number 13 in the name of Neil Bibby is yes 48, no 55. There were no abstentions. The amendment is therefore not agreed. Can I call amendment 111 in the name of Colin Smith, debated in Group 4 yesterday? Colin Smith to move.
Moved.
Thank you. The question is that amendment 111 be agreed to. Are we all agreed? Yes. We are agreed. Can I call amendments 14, 15 and 16 in the name of Neil Bibby, debated yesterday? Move. Neil Bibby to confirm he wishes to move these amendments.
Move.
Those are moved. The question is that amendment 14 be agreed to. Are we all agreed? No. We're not agreed. We move to a division on amendment 14. The result of the vote on Amendment 14 in the name of Neil Bibby is yes 48, no 54. There were no abstentions. The amendment is therefore not agreed. The question is that Amendment 15 be agreed to. Are we agreed? No. We're not agreed. We move to a vote on Amendment 15. The result of the vote on amendment number 15 in the name of Neil Bibby is yes 48, no 55. There were no abstentions. The amendment is not agreed. We turn now to... No, sorry. 15, yeah, good point, 16. So the question is that amendment 16 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a vote on amendment 16. The result of the vote on Amendment 16 in the name of Neil Bibby is yes 47, no 54. There were no abstentions. The amendment is not agreed. We turn now to Group 24, Enforcement Powers, Workplace Parking Levy and Roadworks. Can I call Amendment 112 in the name of Colin Smith, grouped with the amendments as shown, and Colin Smith to move Amendment 112 and to speak to all the amendments in this group.
Thank you, Presiding Officer. Can I move Amendment 112 and speak to all the other amendments in this group which are in my name and which look to tidy up the Bill's provisions on the issuing of warrants to access private premises for the purposes of enforcing the workplace parking levy and conducting inspections relating to roadworks. At points, these powers seem unnecessarily broad, and these amendments will add small but useful caveats. Amendments 112 and 117 clarify that warrants should only be obtained where attempts to enter the premises with permission from the owner have been unsuccessful. The bill, as it stands, says a warrant can be granted if the sheriff reasonably expects to be denied entry. It's not clear what this means or what purpose this serves, and I do not see any reason to have it in the bill. Amendments 113 and 118 place a time limit of 28 days on the execution of warrants. Warrants should not be open-ended, and this amendment simply clarifies the time frame from within which they should be used. I believe 28 days is a reasonable period of time for this purpose. Amendments 115 and 116 clarify the inspection powers the bill introduces in relation to roadworks must only be used within reason. Specifically, these amendments would make clear that the person undertaking the inspection can only retain relevant information for as long as they reasonably consider necessary and can only require the provision of facilities and assistance as they reasonably consider necessary. It's a small but important change which makes clear that the powers granted under this section are not without restriction.
Thank you very much. Can I call Graham Simpson to speak to Amendment 177 on behalf of the Delegated Powers and Law Reform Committee?
Thank you, Presiding Officer. As you say, I'm speaking on behalf of the committee. Section 58N1 was inserted at stage 2 and provides Scottish ministers with the power to make provision about imposing penalty charges connected with workplace parking licensing schemes. As the bill stands, these regulations would be scrutinised by the Parliament using the negative procedure. The Government said the negative procedure is appropriate as the power is procedural and technical in nature. It added that it is equivalent to other powers relating to penalties in the bill on low emission zones and the parking provisions, which are also subject to the negative procedure. The committee agrees with the Government that much of the detail of the power relating to the notification, payment, adjudication and enforcement of penalty charges is better suited to the negative procedure. But part of the power in sections 58N extends beyond merely technical and procedural matters. It includes the power to define the circumstances in which a penalty charge may be imposed. So the power is therefore wider than the powers relating to penalties in respect of low emission zones and the parking prohibitions, where the circumstances in which the penalty would apply are set out on the face of the bill. The ability to define the circumstances in which a penalty is payable in regulations is a substantive power, and as such requires enhanced parliamentary scrutiny. So the committee considers that the affirmative procedure in this instance is the most appropriate vehicle for this part of the power. I move Amendment 177.
Thank you very much. I call Jamie Green.
Thank you, Presiding Officer. Just to speak very briefly to the amendments in this group, 24. We had some reservations about Colin Smith's amendments 112, 113, and also 117 and 118. I was hoping, we were, as I said, unsure in the beginning. We were hoping in the statement that he made that he would clarify exactly why these were important. My concern, and I'm open to hearing what the Cabinet Secretary has to say about this, is that if you start shifting the terms of warrants that are issued in this legislation, it may have knock-on effects in other pieces of legislation where there is enforcement of other types of offences made. I think, to be fair, that if there is deemed a merit in which a warrant is required to access a property, then those that are enforcing that should have all due law afforded to them to be able to carry out that act. And I do have slight worries about the consequence of Colin Smith altering the terms of such warrants. However, we are pleased to support 115 and also 116, which I think inserts an element of protection to the general public in terms of what is or may not be reasonable. So happy to support that.
Thank you very much. And I call the Cabinet Secretary.
Presiding Officer, I'm happy to support Amendment 115 and 116 in this group, which make clear that enforcement officers must act reasonably in the exercise of their enforcement function in respect of roadworks. While not, in my view, strictly necessary, I'm happy to make that requirement explicit on the face of the bill. I'm also content to support Amendments 113 and 118. In practice, warrants for the exercise of enforcement powers in relation to workplace parking and roadworks are unlikely to be needed for more than 28 days, and so these amendments cause no practical difficulties. However, I can't support Colin Smith's Amendment 112 and 117, which would undermine the effective exercise of workplace parking and roadworks enforcement functions. By requiring enforcement officers to apply to gain entry to premises, even in cases where they know it will be refused, these amendments would effectively offer organisations under inspection a window during which they could take action to frustrate the inspection. Pillars of this kind are commonly found in comparable statutory enforcement regimes, and a warrant is granted only where a sheriff is reasonably satisfied on the basis of evidence that entry will be refused. Graham Simpson's Amendment 177 would change the procedure under which certain regulations about penalty charges in association with a workplace parking licensing scheme are made. Although I appreciate the point being made by Graham Simpson here this afternoon, the approach taken by the shape of this amendment would potentially give rise to confusion as to when the affirmative procedure was applicable and when it wasn't, and would lead to very technical provisions being subject to inappropriate level of parliamentary scrutiny. And for these reasons, I cannot support this particular amendment. I would therefore urge members to support Amendments 113, 115, 116 and 118. But I would ask Colin Smith and Graham Simpson not to press their other amendments in this group. However, if they are pressed, I would ask members to reject them.
Thank you. And I call on Colin Smith to wind up in this group and to press or withdraw Amendment 112.
Thank you, Presiding Officer. I mean, these amendments all make what I believe are relatively simple but important changes to the bill's provisions on warrants and inspections. I think we all recognise the need for these enforcement powers, and I'm not looking to hinder them in any way, but rather I'm looking to clarify in law the expectation that they will be used in a responsible and reasonable manner. So I'm happy on that basis to press Amendment 112.
Thank you. So the question is that Amendment 112 be agreed to. Are we all agreed? No. We're not agreed. Move to a vote on Amendment 112. Members may cast their votes now. Amendment 112. And this is a 1 minute division. 1 minute division. The result of the vote on amendment number 112 in the name of Colin Smith is yes 23, no 78. There were no abstentions. The amendment is not agreed. Can I call amendment 113, Colin Smith, to move?
Move.
That is moved. The question is that amendment 113 be agreed to. Are we agreed? Yes. We are agreed. Can I call amendments 17, 18, 19 and 20 in the name of Neil Bibby, all debated yesterday? Neil Bibby, to confirm he wishes to move all these amendments. Move. Thank you. The first question is that amendment 17 be agreed to. Are we agreed? Yes. We're not agreed. We'll move to a vote on amendment 17. Members may vote now. The result of the vote on Amendment 17 in the name of Neil Bibby is yes 48, no 55. There were no abstentions. The amendment is not agreed. The question is that Amendment 18 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division on Amendment 18. The result of the vote on amendment number 18 in the name of Neil Bibby is yes 47, no 56. There were no abstentions. The amendment is not agreed. The question is that amendment 19 be agreed to. Are we all agreed? No. We're not agreed. We'll move to division on amendment 19. Members may vote now. Result of the vote on amendment number 19 in the name of Neil Bibby is yes 47, no 56. There were no abstentions. The amendment is therefore not agreed. The question is that amendment 20 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a vote on amendment 20. Members may vote now. The result of the vote on amendment number 20 in the name of Neil Bibby is yes 48, no 54. There were no abstentions. The amendment is therefore not agreed. We turn now to Group 25, the recovery of unpaid parking charges. Can I call Amendment 172 in the name of Pauline McNeill, grouped with Amendments 173 and 114. Pauline McNeill to move Amendment 172 and to speak to all the amendments in this group.
Amendment 172 is to leave out subsection 2 of section 58U of the bill, where it says it is immaterial for the purposes of this part of the bill whether the vehicle was permitted to be parked or remained to be parked. And Amendment 173 is to leave out the word conveniently from section 58Z1. I have deep concerns about the precedents this sets in the parliamentary process because there was no committee scrutiny whatsoever to this section of the bill. The fact that it was one of many members' bills, which had its own consultation, and I acknowledge that, but probably it's passed many members by as they're busy doing their own bills. There are many aspects of what Murdo Fraser has been trying to achieve here that I would agree with. But my first point is I'm extremely concerned about getting into the practice of inserting members' bills at stage 2. I noted that only 35% of the respondents in Murdo Fraser's consultation were in favour of the concept of keepers' liabilities. It doesn't seem to be there was a majority for that. To me, it's quite extraordinary that the government were prepared just to accept it lock, stock and barrel, and on the basis that it already exists in this form in England and Wales. Is not a satisfactory test. It certainly is not for me. I don't need to tell you that in England and Wales, certainly in England where we had wheel clamping, we did not have it in Scotland. England has trespass laws which you don't have in Scotland. So there's a whole debate to be had here about whether or not actually Scotland has been getting things right, where England might have been getting things wrong. So that deeply concerns me too. There is a debate to be had about access to car registration information by private companies, but that may be for another day. I'm grateful to Paul Wheelhouse, who wrote to me after stage 2 on behalf of Michael Matheson in an attempt to clarify the points that I raised. In section 4B 58U, the bill contains the phrase, "It is immaterial for the purposes of this part of the bill," and makes it clear that the keeper liability provisions are to apply whether or not the vehicle was permitted to be parked on the land, irrespective of whether the driver or the vehicle has a contract in place with a landowner. To me, this creates a clear liability on the keeper of the vehicle. And it seems to me if there's a contract in place, then surely the driver should have the permission of the landowner. The Minister in his letter gave the example of non-residents in a parking bay in a resident-only parking area. But what I took from that, does that mean if you have rights over a parking bay that you can't let your son or your daughter use the spaces allocated to you? If a person owns a parking bay in a residence-only parking area, I mean, why would you need a clause that said it is immaterial as to whether or not permission was given or not? We should strive for clarity in the law and not confusion. And having read this section of the bill several times, I'm certainly confused as to why this is needed at all. Another example, owners of flats in the city centre developments with parking spaces find it impossible to enforce their rights. But again, if you are a city centre owner and you want to give your friend the right to be able to park in your parking bay, I don't see why it should be immaterial for the purposes of whether that permission was given or not. And if I've misunderstood that, I'd be glad to be corrected. The second amendment deals with the word conveniently, and probably this is where my more serious concern lies. It clarifies that the keeper of the car can only be held liable for charges incurred by the driver where the creditor does not know the name of the driver and either the driver's address or an address at which the driver can be conveniently contacted. This provision is in place as it facilitates options for the driver to be pursued before the creditor moves to pursuing recovery from the vehicle keeper. I seek to remove the word conveniently because I'm not clear why it's there. In essence, my concern is, what is the meaning of convenient? Does it mean that they knocked on the door of the driver who was allegedly driving at the time? Does it mean that they turned up to the place of work? And then, of course, there's huge issues about that in terms of data protection. I have to draw Parliament's attention to my serious concerns. I know members around this chamber have dealt with the over-exuberance of private companies who are issuing parking notices unfairly and unlawfully, and we don't even know if the code of practice will isn't enforced yet, but we do know of over-exuberant private companies who issuing these parking notices is of great and utter interest to them. My experience has not been a good one, so we should not let this pass without further scrutiny, or at least without accepting my amendments. Let's not forget, when a parking notice, not a parking offence, when a parking notice is issued, it's only an allegation that you were in breach. You might not actually be. We are giving huge powers here in this part of the bill to private companies who will go after the keeper of the car and not the driver of the car. And I'm telling you, there'll be lots of ordinary people that will be caught out by that. And I think at the very least, we should at least pass my amendments to at least clarify the law. But I'm really unhappy with the whole. I will certainly will. Yeah. Yes,
Elaine Smith. Elaine Smith.
An intervention. I thank Paul McNeill for taking the intervention. Could you just clarify for the Chamber then that the word conveniently is not at all defined in this legislation?
Polly McNeill.
My understanding is it isn't defined, and that's what my concern is, because what the legislation as I read it is driving at is that if it's convenient to go and find the driver, then the creditor should go and do that. Well, we don't know what that means. I don't trust these private companies to use this legislation. What will happen is they will go after the keeper because we've made it easy to do so. And I don't even know if this legislation goes even further than the English and Welsh legislation, because we haven't had a chance to test it. Thank you very much.
Thank you very much. Can I call on the Cabinet Secretary to speak to Amendment 114 and the other amendments in this group?
Thank you, Presiding Officer. Amendment 172 seeks to remove subsection 2 from the section 58U. The removal of this section would significantly limit the reach of the keeper liability provisions, as they would leave considerable doubt about whether they apply to instances of drivers parking in parking areas that they are not permitted to park in, and instances where an allocated parking time has been exceeded. These parking practices are precisely the sort of irresponsible parking that the keeper liability provisions are attempting to address. Amendment 173 seeks to amend the first condition that must be met before a creditor can rely on the keeper liability provisions in the bill. Creditors have the right to enforcement against the driver, but can't as they don't know the driver's name or address. The provisions provided that the latter is to an address at which the driver for the time being resides or can be conveniently be contacted. The word conveniently in this context limits the potential addresses that can be caught by the provision. If removed, the potential addresses, do you let me finish this point first? If removed, the potential addresses at which the driver could be contacted could be very far-reaching. It could also lead to confusion as to what address could be caught and ultimately reduce a creditor's ability to rely on the keeper liability provision. I'll give way to Elaine Smith.
Elaine Smith.
Thank you, Presiding Officer. I thank the Minister for that. And I just pose the same question that I asked Polly McNeill. How do we define conveniently in the law?
Cabinet Secretary.
So, Presiding Officer, the bit that Polly McNeill has not made reference to is that the provisions within this element of this bill tie into the Greg Knight bill that was taken through the UK Parliament and the statutory code of practice that sends out the process that any company using this process must apply those rules, including how they would see an address as being conveniently applied. So there is a statutory code of practice that for the first time deals with the type of rogue companies who are misusing the system as it stands at the present moment. The new arrangements actually make it more suitable to prevent these types of rogue companies from actually exploiting the loopholes that we have in the law at the present time. I'll give way to Mr Rumbles.
Mike Rumbles.
Could you just confirm who it is convenient to?
It's for, within law, it's convenient so that it does not allow them to look for any address that relates to that particular person. And that's what's set out within, will be set out within the statutory code of practice and how that is to be applied. in order to obtain that information. Can I turn to Amendment 114 in my name, which relates to section 58Z4, and it sets out the circumstances under which the keeper of a vehicle may be contacted if a fine remains unpaid by the driver of a vehicle. As it's currently framed, the keeper may be contacted within the period of 28 days, beginning with the day after that on which the notice to the driver was given. This is not quite how the provision should operate. Instead, as in line with the provisions which have been made in England and Wales, it is only once the driver has been given a period of 28 days within which to make payment, but has not done so, so that the notice to the keeper may be issued. The purpose of Amendment 114 is therefore to give effect to this intention. Finally, Presiding Officer, in relation to the matter of keeper liability is not a new process in Scots law. It presently is used in Scots law in a number of areas, including within road traffic legislation. Therefore, it's important to recognise that these are provisions that help to address what are loopholes in the law that can be used by unscrupulous companies seeking to exploit individuals. As each of Polly McNeill's amendments are significantly detrimental to the success of the operation of keeper liability regime, I would urge members to reject Amendments 172 and 173 and to support Amendment 114.
Thank you very much. And I call Elaine Smith to be followed by Neil Findlay.
Thank you very much, Presiding Officer. And I want to speak in support of Amendment 173 in Polly McNeill's name. I think it's worrying that there's been little scrutiny of this particular issue, and I think that also applies to other parts of this bill. Giving more power to private parking companies to track people down is not something I would want to support. Many of these companies operate deeply concerning practices, and as far back as 2009, I lodged a motion in this Parliament about their charges, which I entitled highway robbery. I spent a lot of time challenging the so-called fines that they hand out on behalf of my constituents, particularly elderly and disabled, who feel threatened and worried by the aggressive letters that they receive, and they receive them often for a simple error of displaying their disabled badges upside down, for example. And many constituents just simply cannot afford the exorbitant charges. So I wrote to the DVLA and I asked why they sell driver information to these private companies, and in fact how the GDPR regulations affect that practice. What they say is, and I think this is very relevant to the word conveniently as well in Polly McNeill's amendment, I'm going to read it out for the record. Information about the registered keepers of vehicles can be released by the DVLA under Regulation 27 of the Road Vehicles Registration and Licensing Regulations 2002 and does not require the consent of the individual concerned. This legislation allows vehicle keeper details to be disclosed to third parties who can demonstrate that they have reasonable cause to receive it. Although reasonable cause is not defined in legislation, the government's policy is clear. Requests should relate to the vehicle or its use following incidents where there may be liability on the part of the driver. Well, you know, with these private firms, as Polly McNeill said, how do we even know that there is actually liability? Well, very briefly.
Cabinet Secretary.
Presiding Officer, the bill which was taken through the UK Parliament, the Greg Knight Bill, is specifically to tackle the issue that the member has highlighted. And that's why the provision that's created in this bill is to hook it into that legislation to deal with these companies who might misuse the system. And as part of that, DVLA will only provide the information who have signed up to the statutory code of practice and how the rules apply to that, preventing those rogue operators from getting access to the information.
Elaine Smith.
Presiding Officer, the letter does go on to say some of that, but this letter still says that, what I read out, that it has to be the reasonable cause, which isn't defined in legislation. So no matter the code of conduct, they can still be given the information. And I'm sure that nobody in this chamber condones irresponsible or selfish parking. But there is no doubt that some of these private companies harass and frighten vulnerable people, and that certainly should not be condoned either. This amendment, Presiding Officer, would at least assist in ensuring that some protection exists for keepers of cars, and we should have further debate and discussion about this. It shouldn't have been rushed through, and I urge support of Polly McNeill's amendment.
Neil Findlay to be followed by Jackie Bailey.
Presiding Officer, I fully support the amendments in Polly McNeill's name, because if we do not support the amendments, we're going to give a free hand to the owners of private parking facilities to pursue the owner of a car, not the driver, at the time of any offence, for the value of a fine. The actual driver of the car at that time of the offence could be a family member, it could be a friend, colleague or anyone else insured and with permission to drive that car. And they may have deliberately or inadvertently parked on a site, resulting in a ticket being issued. But as the perpetrator cannot be identified, then the vehicle owner cops for the cost of the fine. Now, no one's saying that no one should be held accountable if there is an infringement, but it has to be the right person, because if not, this is fundamentally wrong. It's like saying we couldn't identify the bank robber, but because we know who owned the getaway car, they're going down for the crime. Presiding Officer, that is fundamentally wrong. The Cabinet Secretary complained rightly about Jeremy Balfour not introducing his amendment at stage 2. But stage 1, sorry. But this wasn't introduced at stage 1. This came absolutely out of the blue. Murdo Fraser introduced a members' bill into this bill. It's absolutely ludicrous, with no scrutiny whatsoever over it. So I would say, please support the amendments. Remove this very bad piece of law, because what you will get is all of us in here being approached by constituents who have cases where they have not committed an offence, but they are being held liable for this. And I really ask SNP members in particular, are they really going to join up with the Tories today to give these powers to private owners? Are they really going to, of all people, support Murdo Fraser? Because that's what you're being asked to do today. So I would say to you, support the amendments in Pauline McNeill's name and throw this out.
Call Jackie Bailey to be followed by Murdo Fraser.
Thank you, Presiding Officer, and I too support Amendments 172 and 173, because this section of the bill gives effect to a Members' Bill at stage 2, which hasn't been scrutinised by the committee and by the Parliament at stage 1, and therefore might have unintended consequences, as illustrated by Pauline McNeill. Now, speakers before me have addressed the substance of this section. I want to consider the process, because the Scottish Government has created a precedent which they usually resist vigorously. Should a member of a backbench, a different party, even the same party as them, attempt to bring something to the chamber which has not been raised at stage 1 of a bill, they are shouted down by government ministers and indeed by their backbenchers. But lo and behold, the Scottish Government are guilty of not practising what they preach, and their benches are silent now. Many of us in this chamber will note the precedent created today by the Scottish Government, and henceforth they will not be able to use that as an excuse to thwart members' ambitions in relation to forthcoming bills. Now, this isn't a party political issue. This is about good parliamentary practice with which we should not be so cavalier. We don't have, Presiding Officer, a second revising chamber. We need to be careful about the scrutiny we undertake, and this falls well short of what is required. Presiding Officer, the other point of note is that the section transposed relates to English legislation and a code of practice. Far be it for me to second-guess the Cabinet Secretary, but I hope he has had this tested against Scots law. And finally, Presiding Officer, I think Pauline McNeill is right to point to the potential for confusion and lack of certainty and clarity. Any law we pass should be clear. This isn't, and therefore may have unintended consequences, despite the Cabinet Secretary's good intentions. So I would urge the Cabinet Secretary to support the amendments from Pauline McNeill.
Can I call Murdo Fraser to be followed by John Finney?
Thank you, Presiding Officer. I wasn't intending to speak in relation to these amendments, but such is the sound and fury and the willful ignorance from the Labour benches around this issue that I think it's worth making a brief intervention. I don't need any lessons about having to deal with unscrupulous private car parking companies. I have had hundreds of constituents contact me around this issue over the last 4 or 5 years, which is what led me to run a Members' Bill consultation on how the law in this area might be improved, which suggested 5 particular reforms, all of which had majority support from those who responded to my consultation. And I welcome the opportunity to work with the Scottish Government to insert some of these reforms into this particular transport bill, which is a very appropriate vehicle to take this forward, given these issues had already been consulted upon with the public. And what the Labour members seem to have missed, and this point was fairly made by the Transport Secretary a moment ago, was that in tandem with this bill, we have had Sir Greg Knight's private members' bill at Westminster, which has now become the Parking Code of Practice Act 2019, a bill, incidentally, which had unanimous support, including from the Labour Party at Westminster, a bill which brings in for the first time a statutory code of practice, I will in a second, a statutory code of practice for private car parking companies. And that means that these private car parking companies will, for the first time, if they do not adhere to this statutory code of practice, will not be able to access records from the DVLA, which they require to enforce these notices. And that is the essential point, and it's a very important one. I'll give way to Polly McNeill.
Polly McNeill.
I appreciate the member giving way. I hope I heard him correctly. I thought you said the majority of the respondents were in favour, but to quote from the official report where you said, in the consultation I ran as part of my members' bill, 35% of respondents were in favour of keeper liability and 33% were opposed. So there wasn't a majority of respondents in favour of keeper. And I can understand that. The reason that people are not in favour of keeper is they're frightened of what it actually means.
Murdo Fraser.
I accept Polly McNeill's point. A majority of those who expressed a view were in favour. And I appreciate there's a slight difference. Nevertheless, I do feel this is a package of reform that is sensible and balanced and fair to all. And it is worth remembering that these provisions in this bill will not be brought into force until the provisions in the Parking Code of Practice Act 2019 are brought into force. So the package will come in on the same date. It's also worth remembering, there are many people who have a legitimate interest in trying to protect their parking rights. I've been approached by the owners of flatted developments in town centre developments, where the owners are absolutely sick-fed up of their inability to stop members of the general public just coming in and using their parking spaces, because at the moment the law is not sufficiently clear to allow them to do that. The same applies to the owners of businesses with allocated parking, perhaps for workers, perhaps for customers, where members of the public will come in and park without permission. It's very difficult to enforce that. So there's legitimate interest in protecting people's interests in terms of their parking spaces, but we only can do that in a balanced and sensible way. And what is proposed in this bill before us, coupled with the Parking Code of Practice 2019, as passed at Westminster, is a package supported by groups like Citizens Advice Scotland, supported by the British Parking Association, supported by a range of stakeholders who see this as a sensible and balanced way in which to proceed. So I would encourage members to support the bill and to reject amendments 172 and 173.
Briefly, John Finney.
Thank you, President Officer. I hear the concerns of my colleagues here. I wouldn't ordinarily be getting up and speaking in support of Mr Fraser there, but what he's brought forward and what is in the bill has brought some welcome clarification, and I'm certainly happy with it.
Thank you very much. And Polly McNeill to press or withdraw Amendment 172.
Press.
Sorry, Polly McNeill, yes, to conclude this section.
Did I get to sum up?
Yes, you're allowed to sum up, yes.
Pressing it.
And to press. Thank you. The question is, the Amendment 172 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote on Amendment 172. So in that case, it wasn't clear from what you were asking me. I thought you were allowed to sum up. Did you wish to add any comments?
Please, yes.
Very briefly, Mr McNeill.
So I don't wish to unnecessarily detain members, I really don't, but I didn't feel that some of the questions that I addressed specifically about landowners who gave permission, I didn't feel I had an answer to that. So we don't know yet whether the statutory code of practice, which I do take Murdo Fraser's point, but we don't know if it will deal with rogue companies yet. We don't know that yet. It was taken through Westminster, and that's the point. It should also have been taken through this Parliament. Remember, these charges are in excess of charges which local authorities tend to... I've seen charges of £80 and £90. Keeper liability already exists, as the Minister says, but that isn't our public and criminal law. What you have been asked to do is give the concept of keeper liability to private companies. Neil Findlay is absolutely right. Some people inadvertently park. I know people who didn't realise that parking at 9 o'clock in a town centre when everybody had gone, that there was a contravention of the parking notice in a dark night. Well, will the Code of Practice deal with that? Well, I'd like to know that for sure. And I conclude with this. I still go back to the points that Elaine Smith and Jackie Bailey made. It is not clear what this issue of if it is convenient means. I just read it straightforwardly. I didn't read. And I'm not really clear how the Minister can clarify to me what the meaning of something is which he didn't actually write, because it wasn't written by him, it was written by Murdo Fraser. So that seems odd to me that he can give me clarification where they did absolutely no scrutiny on it themselves. Must a record be shown, perhaps at some point in the day, because the Minister could say whether the creditor would be required to show what efforts they made to try and find the driver? I would at least have been happy if we could have inserted something like that. Thank you.
Thank you very much, Ms McNeill. Sorry for that confusion. So the question is that Amendment 172 be agreed to. Are we all agreed? No. We are not agreed. So we're going to move to a vote on Amendment 172. This is the first vote after a division, after a group, so it will be a 1-minute division. Members may vote now. The result of the vote on amendment number 172 in the name of Polly McNeill is yes 23, no 80. There were no abstentions. The amendment is not agreed. Can I call amendment 173, Polly McNeill, to move or not move?
Move.
That is moved. The question is that amendment 173 be agreed to. Are we agreed? No. Not agreed. Move to vote on 173. It's a 30-second division on amendment 173. The result of the vote on Amendment 173 in the name of Polly McNeill is yes 22, no 80. There were no abstentions. The amendment is not agreed. I call Amendment 114, Cabinet Secretary, to move.
Moved.
The question is that Amendment 114 be agreed to. Are we agreed?
Yes.
We are agreed. Can I call Amendments 115, 116, 117, 118, 119 and 120, all in the name of Colin Smith, already debated. Colin Smith to confirm whether he wishes to move or not move all of these amendments.
All moved, President Officer.
All moved. The question is that Amendment 115 be agreed to. Are we agreed? Yes. We are agreed. The question is that Amendment 116 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Amendment 117 be agreed to. Are we all agreed? No. We're not agreed. We'll move to division on 117. Members may vote now. Amendment 117 in the name of Colin Smith. The result of the vote on Amendment 117 in the name of Colin Smith is yes 22, no 81. There were no abstentions. The amendment is not agreed. The question is that Amendment 118 be agreed to. Are we all agreed? Yes. We are agreed. The question is that Amendment 119 be agreed to. Are we all agreed? Yes. We're not agreed. We move to a division on Amendment 119. Members may vote now. Amendment 119 in the name of Colin Smith. The result of the vote on amendment number 119 in the name of Colin Smith is yes 77, no 25. There were no abstentions. The amendment is therefore agreed. The next question is that amendment 120 be agreed to. Are we all agreed? Yes. We're not agreed. We'll move to a division on amendment 120. Members may vote now. The result of the vote on amendment number 120 in the name of Colin Smith is yes 77, no 25. There were no abstentions. The amendment is agreed. Can I call amendments 121, 122, 123, 124 and 125, all in the name of the Cabinet Secretary, all previously debated, and can I invite the Cabinet to move amendments en bloc?
Moved.
Moved. Does any member object if I put the question on these amendments en bloc? No one does. So the question is that amendments 121 to 125 inclusive are agreed to. Are we all agreed? Yes. We are agreed. Thank you very much. We're going to turn now to Group 26, Road Orders. And can I call Amendment 174 in the name of John Finney, grouped with Amendment 175. John Finney to move Amendment 174 and to speak to both amendments.
Thank you very much indeed, Presiding Officer. I'll be brief. I think the Chamber's agreed we need to have more active travel, walking and cycling, and one of the biggest barriers to that is a lack of infrastructure such as wider pavements and segregated cycle lanes. Now, in order to deliver that safe infrastructure, local authorities must pursue a legal process called a Redetermination Scotland Order, or RSO. At present, if there are unwithdrawn objections to such an order, the matter must be referred to Scottish ministers. This can delay a new cycle path, for instance, by up to 18 months. Now, I brought forward an amendment at stage 2 and didn't proceed with it. But the amendment that's before you today does not seek to alter the process for the redetermination orders. Rather, it seeks to transfer them from primary to secondary legislation. Any agreed changes to the RSO process can therefore be made in due course through amendments to a statutory instrument. Once that further consideration, and if necessary consideration with stakeholders has taken place. As we know, changing secondary legislation is a lot quicker and easier than waiting for a new parliamentary bill. And just to advise members that this amendment has the support of COSLA and Age Scotland. With regard to Amendment 175, Presiding Officer, I'd like to apologise to the Chamber. This was incorrectly drafted, and I would seek permission to withdraw that amendment. Thank you.
Can I just clarify, which amendment is Mr Finney withdrawing?
I press 174 and I seek to withdraw 175, please.
Thank you very much. Can I call Claudia Beamish to be followed by Edward Mountain?
Thank you, Presiding Officer. I too support Amendment 174 by John Finney, simplifying the RSO arrangements to remove the overtly difficult barriers specifically to active travel. We should be simplifying processes like this, as active travel uptake is indeed in need of a boost. The Edinburgh West East City Centre cycle route government inquiry is still underway after a year, after formal objections to the council scheme. Edinburgh Council responded to the inquiry, refuted all the objectors' arguments, showing the scheme to be in line with council and government policies, and has taken on a vast amount of time and effort from Edinburgh City Council. Furthermore, the same kind of delay is expected with the second phase of the project, as I understand from some people in Edinburgh through Spokes Lothian. This key example is in Edinburgh, and it often depends whether there is a determined local objector. But it is notable that Glasgow City Council, as well as COSLA, highlighted by John Finney, are also in support. These problems and inconsistencies can have such a big impact on cycling infrastructure projects and are often about very localised decisions and should, in our view, be sorted out in secondary legislation. And as co-convener of the cross-party group for cycling, walking and buses, and a wary urban cyclist, I'm supportive of these amendments. Thank you.
Thank you. I call Edward Mountain to be followed by Colin Smith.
Thank you, Presiding Officer. First of all, I'd like to thank John Finney for withdrawing 175, which I didn't fully understand. But looking at 174, which is built onto the amendment that he put in at stage 2, 321, I read back to what the Cabinet Secretary said about taking this out and putting it into the TRO process, which is where I believe this is going. I would just like confirmation for the Cabinet Secretary that there will be sufficient consultation with those people who are involved with this under the section 3 of 174 that have been put forward by Mr Finney, and also that that consultation will form part of the notification once the order has been made. Subject to those agreements, Presiding Officer, this party would be prepared to accept the amendment.
I call Colin Smith.
Thank you, Presiding Officer. I welcome Amendment 174 in John Finney's name, which will lay the groundwork for much-needed simplification to the TRO and RSO processes. The costly and onerous TRO process can often act as a barrier to a range of positive measures, such as lowering speed limits to developing active travel infrastructures. Simplifying these processes will reduce the burdens on local authorities at a time when resources are already incredibly stretched and help facilitate the changes needed to encourage a model shift in our transport system. The Government have repeatedly stated that they intend to review the TRO process, and this amendment aligns well with that plan. So Labour will be voting for Amendment 174 when the time comes.
Thank you. Cabinet Secretary.
Presiding Officer, Amendments 174, 175 by John Finney relate to the order-making process for the redetermining the means by which the public right of passage over a road may be exercised. Amendment 174 amends the Road Scotland Act 1984. It replaces existing power to make procedural regulations for redetermination orders, which is subject to a requirement for a local roads authority to refer an order to which objections are made but not withdrawn to Scottish ministers, with a wide power to make procedural regulations, which is not subject to that requirement. If you're still with me. As I said during stage 2, any changes to the procedural requirements for these orders would require careful consideration of the balance between the needs of road users and maintenance of a robust and fair procedure for considering public objections. It's not considered appropriate to make any such changes at this particular point. The Scottish Government has, however, committed to reviewing the procedure attached to road traffic regulation orders and road orders. It is considered that the wider power conferred by Amendment 174 would provide greater flexibility to respond to the outcome of that review, whatever that may be, within the existing powers. It should be noted that the existing procedural regulations would remain in place during the review process and until any new regulations were made. Therefore, the content of any new regulations would be subject to consultation, and that's a matter which also would be considered by the Parliament. I would therefore support Amendment 174, and I would urge members to do likewise. Given that Mr Finney does not plan to move Amendment 175, I'll refrain from making any further comment in that area.
Appreciate that, Cabinet Secretary. Mr Finney to wind up and to press or withdraw Amendment 174.
Press and thank members for their comments. Thank you.
Thank you, Mr Finney. So the question is that Amendment 174 be agreed to. Are we all agreed? Yes. We are agreed. I can just confirm that Mr Finney does not wish to move 175.
That's correct. Thank you, Mr. Officer.
175 is not moved. I call Amendment 126 in the name of Colin Smith. Colin Smith, to move or not move?
Moved.
That is moved. The question is that Amendment 126 be agreed to. Are we agreed? Yes. We are agreed. Can I call Amendment 176, Colin Smith, to move or not move? This is 176.
Moved.
That is moved. The question is that Amendment 176 be agreed to. Are we agreed? Yes. That is agreed. Can I call Amendment 22 in the name of Graham Simpson? Graham Simpson, to move or not move? That is moved. The question is that Amendment 22 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 127, Cabinet Secretary, to move?
Moved.
Thank you. The question is that Amendment 127 be agreed to. Are we all agreed? Yes. We are agreed. Can I call Amendment 21 in the name of Neil Bibby? Neil Bibby, to move. That is moved. The question is that Amendment 21 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote on Amendment 21. And this will be a 1-minute division. Amendment 21 in the name of Neil Bibby. The result of the vote on amendment number 21 in the name of Neil Bibby is yes 48, no 55. There were no abstentions. The amendment is not agreed. Can I call amendment 177 in the name of Graham Simpson? Previously debated. Graham Simpson, to move.
Move.
That is moved. The question is that amendment 177 be agreed to. Are we all agreed? No. We're not agreed. We'll move to a vote. Members may cast their votes now on amendment 177. The result of the vote on amendment number 177 in the name of Graham Simpson is yes 48, no 55. There were no abstentions. The amendment is not agreed. Can I call amendments 128, 129, 130, 131, 132, 133 and 134 and invite the Cabinet Secretary to move the amendments en bloc?
Moved.
Thank you. Does any member object to a single question being put on these questions? We do. Okay. In that case, sorry, to clarify, Mr. Green, which amendments?
If it's helpful, 128 to 133, I'm happy for them to be proposed en bloc.
So we can move 128 to 133 en bloc?
Indeed.
In that case, can I invite the Cabinet Secretary to move one spot? He moved already. So I will put to the Chamber, the question is that we accept, that we agree amendments 128 to 133 en bloc. Are we all agreed? We are agreed. The question is that amendment 134 be agreed to. Are we all agreed? We're not agreed. We'll move to a vote on amendment 134 and members may cast their votes now. The result of the vote on amendment number 134 in the name of Michael Matheson is yes 73, no 30. There were no abstentions. The amendment is therefore agreed. And that ends consideration of amendments. Point of order from Jamie Green.
Thank you, Presiding Officer. I appreciate members have had a long couple of days on the Transport Bill, but I did want to comment further to Chapter 9 of the Standing Orders around public bill procedures. We're just about to have a Stage 3 debate on the Transport Bill. That debate has been curtailed, Presiding Officer, to just 45 minutes, with our party having only 3 speakers. Other parties have had their debates curtailed. We're just about to pass a piece of Stage 3 legislation for a fairly substantial piece of legislation. I do not feel that 45 minutes is an adequate amount of time to properly debate such a... I'm surprised that members are in disagreement because we're just about to pass law, Presiding Officer. Now, I appreciate the business managers, and I know others have presented this argument to the Chamber. The business managers have agreed the timetable for today. Indeed, the Parliament voted for it at 11:40. But that doesn't make it right. This is not how we make good law in this place. Correct. And I'd like to express those concerns to the Presiding Officer.
Thank you, Mr. Green. Thank you, Mr. Green. I can also thank you for advance notice of the point of order. The point is noted. The point was also raised, I think, very similar terms by Murdo Fraser earlier in the day, and it picks up on similar points really made by members yesterday. These are matters which are taken into consideration by the business managers in the Bureau, and they do take a lot of time to consider the balance of members' needs. The process at Stage 3, in fact, a bill process is supposed to be comprehensive, but that doesn't mean to say that every single member gets to speak for as long as they want, or as often as they want. So it's exhaustive but not exhausting. And in this case, members did take all factors into account and did decide that we would be able to curtail this debate with the agreement of the Chamber. That was put to the Chamber did vote and agreed it. But the point is noted and will be considered by the Parliamentary Bureau in future matters. On that note, can we move, before we move to the next item of business, as members will be aware at this point, I am required under standing orders to decide whether any provision in this bill relates to a protected subject matter, that is, whether it modifies the electoral system or franchise for Scottish parliamentary elections. In my opinion, it does no such thing. Therefore, it does not require a supermajority at Stage 3. So that concludes consideration and the determination, and we'll move on very shortly to next business.